So today we're talking about an introduction to the Proceeds of Crime Act 2002 and confiscation orders. What is a confiscation order is the first question on people's minds. It's an order that the court can pass to obtain money obtained in the course of criminal activity. The background to it is in 1986 the courts realised that they had very limited powers to seize money off defendants who were convicted of serious and high value crime. And so initially the Drug Trafficking Act 1986 was introduced, by which the courts had powers to make confiscation orders for the first time. Since then the law has developed over the course of time. There's been the Drug Trafficking Act 1994, the Criminal Justice Act 1988 and the current legislation, which is the Proceeds of Crime Act 2002, which is still used by the courts today. The question arises for most people, what is a confiscation order? It's an order which the court passes after the sentence or as part of the sentencing procedure, in which two nominal figures are made in relation to the benefit somebody has made from a crime and what assets they have to pay towards that benefit figure. So two figures are essentially obtained, and the difference between the two can still be owed once a confiscation order is passed. What's important though in relation to confiscation orders is they follow a substantive crime conviction, and when somebody is interviewed for the original substantive crime, they are often interviewed in relation to issues which will then also be relevant in the Proceeds of Crime Act confiscation proceedings. So it's very important to have the Proceeds of Crime Act proceedings and the confiscation order in mind when the initial interview is done for the substantive matter, because the interview can be used to ascertain what figures will be relevant for the confiscation order.